Good morning to everybody out there getting ready for the Sarah Boone hearing in the middle of jury selection as this is going on. I'll tell you one thing. All of you do not have to wake up at 2:30 in the morning in order to make it for today's hearing. So one advantage that you have to not being in Sarah Boone's position. So we are waiting it. I'm looking at it. As soon as it goes live, I will post it for all of you. I do want to acknowledge Cindy. Thank you for streaming, Brother Counsel. Appreciate your calm evaluation of the law in this case. We try to bring reason and calm and objectivity to all of the cases that I analyze. So I'm glad that you appreciate that. I'm glad that you see that. Thank you, Cindy. There were some late night filings by Sarah Boone's defense team. And I'm going to go look at them. They were not available to be downloaded the last time I checked, but I will tell you what the topic is. Well, actually, now we just got one. All right. So I'll pull it up as we're waiting. This is a response to the state's motion in limine to exclude the battered spouse syndrome evidence. So this is the defense's response. Now it looks like they actually have two responses, because why should one be enough? So let me pull it up as we're waiting, and we can go through it together. This is the first time I'm actually looking at it, so you will be right along with me as I'm going through this. But in the meantime, I'm going to have to actually stop the other one. All right, let's see if I can pull up the right thing on the fly. Here we go. Defendant's response to state's motion in limine. Okay, well, here it is. This is what they filed last night. Looks like it came in at 9:15 p.m. Talk about a late night filing. So you think the judge got a chance to read this? Not sure. So they may have to just argue it orally. But in the meantime, let's blow it up for all of you. And we'll go through it. On September 20th, 2024, this court found defendant's notice and amended notice of intent to rely on battered spouse defense complied with Florida Rule Criminal Procedure 3.201. Now remember, as we spoke about in the past, there was a notice. There was an amended notice, which is what you have to do in Florida to let the other side know that you will be relying on battered spouse syndrome as part of your defense. As we said, it's not a self-defense in itself, but is part of your defense. It can bolster your defense. And the judge did find that their notice and amended notice complied with the rules of criminal procedure. So even though the state moved to exclude it or to strike it, the court allowed them to continue and said that the notice is fine. So this motion in limine really is a very, very similar to that motion to strike the notice. Accordingly, the state's motion to strike defendant's notice was denied. That's exactly what we spoke about. To date, the state filed a motion in limine to exclude battered spouse syndrome evidence or any mention thereof until the defendant testifies to something that is a justifiable use of deadly force. That was what the state's motion asked for. Remember, the state asked that the defendant should only be allowed to argue battered spouse syndrome. And by the way, as soon as it goes live, I'll stop reading and we will just right away go to the live stream. But it has not gone live yet, so I am watching it. So in the meantime, we're just going through this motion. All right, so this is actually the response I got in very, very late in case you're just joining us now. So we have the states filed a motion to exclude the battered spouse syndrome evidence. You can't make any mention of it until the defendant testifies. And remember, like I keep telling you, they keep daring Sarah Boone to take the stand, and she may actually take the bait. So we'll see. She's the one that's calling the shots here, right? So, however, the state's contention is without merit. In fact, this is no more than a final attempt by the state to strike defendant's intent to rely on battered spouse syndrome and or prevent the mention of such in voir dire and opening. So again, they're just simply saying what I've been mentioning. Excuse me. Still, the last little bit of this COVID is getting out of my system, so I apologize for that. All right, so like I said before, this is really the state's motion to strike the defendant's intent to rely on battered spouse syndrome dressed up as a motion in limine. So it's all the same essential arguments, except they did bolster their motion a little bit better, a little bit different. But anyway, let's continue. Legal argument. Battered spouse syndrome is not a defense in itself, as we've spoken about many, many times. it is used in conjunction with self-defense. When self-defense is asserted in a criminal case, the defendant only has the burden of presenting some evidence to establish a prima facie case that the killing was justified. So all you have to do is provide some evidence, and they're quoting a case here. The state of Florida must then prove beyond a reasonable doubt that the defendant did not act in self-defense. See Sipple versus State. So since this is the first time that I'm reading it together with all of you. I'm not able to go look up Sipple versus State. Well, I could, but then we'd all have to spend some time reading that opinion together, which I don't think you guys want to do. But normally, that's exactly what I would do to prepare for my next video on Brother Counsel. I would look up this case, Sipple versus State, which is probably what a lot of other channels don't do, and I would read it, analyze it, see if there's any other cases that have anything to say about this, and see whether this quote is actually a true assertion of what that case stands for. But anyway, let's just assume that they're actually quoting it right for the purposes of this right now, what are analyzing now. Okay, so they're arguing that the defendant only has the burden of presenting some evidence to establish a prima facie case that the killing was justified. Okay, and then once they provide some evidence, then the state of Florida must then prove beyond a reasonable doubt that the defendant did not act in self-defense. The state can meet its burden through rebuttal or by inference in its case in chief. See Tillman versus State. It's another case I'd probably look up. Furthermore, a scintilla of self-defense evidence presented by the defendant warrants the instruction. So even a scintilla in which this court must provide if there is any evidence to support the theory, regardless of how weak or improbable the evidence may be. See Gonzalez versus State. So as long as you have some sort of evidence of self-defense, then you can argue self-defense. The judge is required to give the jury instruction about self-defense, and and it doesn't matter how weak or improbable the evidence may be, as long as you have some scintilla, a smallest amount of self-defense evidence, then it would definitely come in. It then becomes the jury's role to weigh the evidence, not the state. To that end, it is simply too early procedurally to require the defendant to meet her prima facie case of self-defense. So they're arguing back that you, state, are arguing that we should have to have Sarah Boone take the stand in order to even mention the argument of battered spouse syndrome. That's simply not true. As long as we provide any sort of evidence at all of self-defense in general, as a general category. Remember, self-defense is a general defense. That has nothing to do with battered spouse syndrome. Battered spouse syndrome is just to bolster your self-defense. So when you have this self-defense, you have some sort of evidence of self-defense, then they're going to argue. So therefore, once we provide a drop of evidence of self-defense, then that automatically will open the door to be able to argue battered spouse syndrome and mention it during voir dire, etc. Purpose of voir dire. And I know some people take issue with how I'm pronouncing voir dire. Some people say voir dire, and I'm sure there's a lot of other ways to pronounce it, but that's how I've been trained. So I call it voir dire. To exclude the mention of battered spouse syndrome before the defendant testifies would be a miscarriage of justice and ultimately infringe upon her right to a fair trial. The purpose of voir dire in Florida criminal proceedings is to obtain a fair and impartial jury. Yeah, sure. That's the general purpose of voir dire. But as I have a trial coming up November 4th, and let me tell you, the good attorneys spend a lot of time on formulating their questions about what they're going to be asking the jury in voir dire, because it's not just to obtain a fair and impartial jury. You're right, that's really the general purpose. But what we're really doing by voir dire, the good attorneys, they're really already starting to plant seeds and see whether the jury's going to be accepting of some of the arguments that they're going to be making. And that's exactly what you start planting the seeds already in voir dire. And then later, when they hear some of the arguments in opening statement or closing arguments, then they'll already be familiar with where you're going. But anyway, defense counsel may inquire of veneer their willingness and ability to accept an affirmative defense. So that's one of the areas which you're allowed to ask in voir dire, is to ask the jury, to see whether they're even able to accept something called an affirmative defense. An affirmative defense is simply where you're saying we are acknowledging that we did this thing. Let's say Sarah Boone did actually kill George Torres, but she had a justified reason for doing it. That's called an affirmative defense, meaning you're admitting to the action, but you're still arguing that you were permitted to engage in that action. So that's an affirmative defense. And you are allowed to, on voir dire, to ask the jury, what do you feel about such a affirmative defense? What would you feel about that? Do you think that that's fair? Do you think that that's okay? Would you be able to swallow that? Would you be able to follow the law as it pertains to affirmative defenses? Things like that. So that's a Walker versus State. See also Harrison versus State. Finding that the trial court abused its discretion in unreasonably limiting defense counsel's ability to question prospective jurors on the sole defense presented at trial. And again, for anybody just joining now, I'm keeping track of the live stream. It has not started yet, so as soon as it does, we will cut to that. But in the meantime, we are going through the Sarah Boone's response to the state's motion in limine, and this response was filed late last night, 9:15 at 9:15 last night. So that's why we're going through it now, and this is most likely what we're going to be hearing some of the arguments today during the hearing. All right, continuing. And the judge must allow counsel the opportunity to ascertain latent or concealed prejudgments by prospective jurors. Whether a trial judge should have allowed interrogation of jurors on specific subjects is reviewed under an abuse of discretion standard. So an abuse of discretion is the hardest to show that the judge abused his discretion. So essentially, whatever the trial judge decides to do in terms of what type of questions you're allowed to ask the prospective jurors, it's only going to be overturned on if he abused his discretion. Specifically in Simpson, they quote Simpson versus State. Specifically in Simpson, the court reversed and remanded the matter for a new trial, opining that battered spouse syndrome was at the heart of Simpson's defense, and because the trial court did not permit her attorney to inquire into possible juror bias on that issue, the trial court abused its discretion. So here was the case, specifically this case, Simpson versus State, and of course, like for all of you legal scholars out there, this is a case that you'd want to look up, Simpson versus State, because they're quoting Simpson versus State for a very important holding here, and that is that the judge did not allow the counsel to talk about battered spouse syndrome, and because the court did not allow them to do that, the court was reversed, and it was remanded for a new trial because since battered spouse syndrome was at the heart of the defense, and the court did not permit the attorney to inquire to the possible jurors about that, so they were reversed. The court was reversed. So that's a strong argument. That's an argument that you make to this judge saying, look, if you're not going to allow us to even talk about this to the jurors, the prospective jurors during voir dire, well, then this is a reversible error. And even though it's an abuse of discretion, it's considered abuse of discretion, even though that's the standard, which is very high. But you see that this court specifically said that it's an abuse of discretion. Now, the reason why you have to look up Simpson versus State is because I am curious about what the evidence of battered spouse syndrome was in that case. Probably, if I had to guess, it was probably very different than some of the facts and the evidence that we have in this case of Sarah Boone. So if you're the state, and if you had time, you would look up this case and you would most likely say, Your Honor, this case of Simpson versus State was completely distinguishable because there is, and by the way, I don't know why they didn't put a year here. This seems like an incorrect quote, or not a full quote here, because they don't have the end. They don't have the end here, like the year. But anyway, you'd be able to find it if you probably just put this in the Google search. But the point is that the state would most likely look up this case and say, no, this case was completely different, and the evidence of that battered spouse syndrome was screaming, and that's why in that case it was reversed. But anyway, let's move on. Therefore, the defendant shall be permitted to mentioning and inquiring as to juror bias regarding battered spouse syndrome, justifiable use of force, and self-defense at all relevant times. Now, remember the state Wagner versus State case. This is the case that the state keeps talking about, which is the argument that if you're going to argue that this was an accident, you cannot argue self-defense. The two theories don't work together. They don't work in tandem. They don't make sense together. So that's what Wagner versus State stands for. So Wagner does not preclude a defendant from asserting self-defense and getting the battered spouse instruction because of statements made by the defendant before trial. See Wagner versus State, holding that a defendant is unable to proceed with both battered spouse syndrome and accidental killing defenses at trial. So again, this is not a full quote. This doesn't really do justice to the argument of how you would want to present this argument to the judge. if you're going to make this type of argument, you have to say specifically. And again, this was me. I'd go into Wagner versus State. I remember some of the details of Wagner versus State, and some of the details include that the argument that the defense made in his closing argument was that this is all one big accident. So they took on that argument. So if they take on that argument and they embrace the argument throughout the trial, then you can't ask for a battered spouse syndrome instruction as well. So how much they dug themselves into this defense is important, but that's something that you would want to talk to the judge about. I mean, talk to the court when in your filings, or write about in your brief that in Wagner versus State, what happened in that case was the following: A, B, C, D, and E, and all of those things were not just statements that the defendant made before trial. Actually, what happened in Wagner versus State is that they presented evidence. They had depositions. They had experts. They had different evidence saying that this was one big accident, and that's how they presented their case. And then maybe in jury instructions, when they're talking about jury instructions, they just said they asked for a battered spouse, and the judge said, "I'm not going to give it because your whole case was, and your whole theory was based on accident." So if that's what happened, then they should just do a little bit better job here of arguing this against Wagner versus State. But that's essentially, if that's all true, then it does stand for the proposition that just because the defendant said something in their interrogation doesn't mean that it's automatically considered an accident, and that's the argument that's the theory that they have to use in trial, meaning they're not stuck with that theory and they could change theories. And the state really acknowledged this in their motion. If you remember, the state said even if that Sarah Boone wants to change her theory of how this all happened, well, she would have to take the stand. So they acknowledge that you're not stuck with what you said in your interrogation with the detectives. Nevertheless, they still want more evidence to be presented before they can argue battered spouse syndrome. Again, however, in the instant matter, defendant has not testified at trial yet. Thus, the state's reliance on Wagner is misplaced. Wherefore, the defendant, Sarah Boone, respectfully moves this honorable court to deny the state's motion in limine to exclude battered spouse syndrome evidence or mention of battered spouse syndrome evidence until defendant testifies. So that is the defense's response to the state's motion in limine to exclude all of this mention. Well, we are still waiting on the live stream, and maybe there was some traffic in getting Sarah Boone there. So we are still waiting, but I do want to also make a mention here that there's another response that they filed. So that was one response, and then there's an amended response. Let's see what their amended response says. See if it changes anything. So we'll pull this up. Again, I am watching the live stream carefully. As soon as it goes live, I will live stream it as well. But we're still waiting on that. So this is the amended response filed by Sarah Boone's defense team after we just went through already the other response. See here, now it says defendant's amended response to state's motion in limine. So let's see if this is a lot of the same. This is a lot of the same. This is all the same that we already mentioned, so we're not going to read it over again just to waste time. This is all the same. What exactly are they changing here? Let's see. Okay, I do not see anything in this amended response that is anything different than the response that we just went through. So I don't know what they added or took out. I do not see anything. So, all right, well, then I'm not going to waste everyone's time and read the same thing that we just read again anyway. All right, so let me see. And I was not paying attention to the comments. So let me see if there's any comments here that we can show for everybody. We can always show the thank yous. Thank you, brother Counsel. No problem. That's why I'm here. Help make this all make sense. Good morning, Sunshine Mitch. Good morning, Just Joe. Love from Michigan, from Point Blank Guns and Ammo. Thank you. If you're from Michigan, so am I. I am located in Southfield. That's where my office is. Hopefully you won't need any attorneys, but in case you do. Look up Radner Law Group. All right. Good morning, Shay. Okay. Good morning, Jennifer. D. Good morning, Sonata. And if you guys have any questions, I'm definitely will put those up too. Good afternoon from London. All right, we got London in the house today. We are an international show here. Chloe's mom. Good morning, brother Counsel and chat. And respect from South Africa. All right, we got South Africa in the house today. And Denmark. Afternoon from Denmark. Actually, my in-laws, father-in-law was born in Denmark. And his family lived in Denmark before he had to escape because of the war. Joanne Keefe. Good morning, brother Counsel. You're the best. Thank you for going live. Thank you for that. I appreciate that. And this will be, unfortunately, my last little bit piece of coverage of Sarah Boone until the Jewish holiday is over. So again, the Jewish holiday begins tonight at sundown. And then we have the rest of this week and the following next week. Also, the holiday extends. And then after that, I will be back in action. Although I do have a trial coming up November 4th. So we're going to have to work it all out. Don't worry. We will do our best. As soon as the holiday's over, I'm going to be hitting the Sarah Boone trial, watching everything on double speed as fast as I can, making notes, and then hopefully maybe I'll even recap the entire week of trial in one video under an hour. How would that sound? That's a good challenge. So we'll see if I can actually do that. But this trial prep that's coming up for this November 4th trial is a little bit annoying. We had a late deposition last night. 2 depositions last night. And again, I am watching the live stream. It didn't start yet, so it's not just me talking for no reason. All right. But yeah, we had a late night last night, thanks to some depositions. And then finally I got home and it was just a late night. Kim Hastings, good morning, brother Counsel and chat. And thank you also, Kim. I noticed that you did order some merch from Brother Counsel merch. And that is available for everybody. It's the greatest merch because it stands for something that doesn't really exist so much in this world, and that is objectivity. That's part of the reason that we started this channel, is because we want it to be objective and just bring out the arguments, explain everything, and let everybody else kind of make their own conclusions and decisions. Of course, I will give my opinion if it's necessary, but it's usually objectively based on the evidence and facts of the case. So if you check out the merch, it is all about objectivity. That objectivity exists in this world, and if you are a follower of Brother Counsel, then you are probably also looking and appreciate objectivity. So definitely some merch that you should own and wear proudly, that you are one of the few people left in this world that are objective. Helene Schmidt, most defendants in Denmark are taken to the stand and testify. That's why USA trials are so weird, I guess, due to our standard. Yeah, we have the Fifth Amendment here. Fifth Amendment does not require protects you from incriminating yourself. So you do not have to take the stand if you're going to testify against yourself. And again, for everyone joining now, we are keeping an eye on the live stream right now. And as soon as it goes live, we will live stream it here as well. But for some reason, there is some sort of delay going on, which I don't know. I'm not in the courtroom. But as soon as they go live, we will live stream it. Lila Wild, but she still hasn't said I intentionally killed him. How can there even be a scintilla of evidence when she maintains it was an accident? Well, the evidence is not just limited to what she has said to the police in her interrogations or her interviews. It's not limited to that. If there is some sort of evidence of domestic violence, perhaps prior domestic violence, so there can be some, alcohol and maybe some other testimony that there was always fights going on, and experts that are going to submit reports, Dr. Julie Harper. So that can suggest that there was perhaps an action of self-defense here. But yes, not such great evidence of self-defense that we have seen so far. Well, a good afternoon to you, Scissor Man. It's morning here in Michigan, but wherever you are, I'm assuming it's afternoon. So good afternoon to you. Just Joe, thumb it up, people. Yes, definitely hit that like button. We are still waiting for that live stream. As soon as it goes live, we will live stream it. So definitely hit the like button. If you haven't yet, subscribe. We've got to get our numbers up, because what we're doing here in Brother Counsel, at Brother Counsel Studios, is really we're changing how true crime is being covered. I think that's part of the reason why I started this. I'd like to change the way that true crime is being covered. I want it to be with more lawyerly in the way that you actually look into the statutes, look into the case law, not just read some of the motions through like I did today, even though sometimes you have to do that, but actually break things down from a legal perspective. So that is part of what I'm trying to do here. Change the way that true crime is being covered by lawyers, raise the bar, if you will, so that it'll increase, it'll cause everyone to do a better job, cause everyone to do more research and to put more thought and time into the videos that they're putting out and into the analysis that they're putting out. And that way, the entire true crime broad people who are covering this will raise the bar for everybody. So definitely help us out in that. I can only do it with your help. I think that a lot of people have realized that that's what we do here. We're trying to raise the bar in how true crime is covered. Good morning from California. So California is about 3 hours behind, right? Good morning to you. Morning, Peter. I'm not even going to take a stab at that last name. Looking forward to this case. Yeah, I think a lot of people are. And you know, it's just absolutely crazy. It's absolutely nuts. And there's got to be some sort of psychological reason or diagnosis why Sarah Boone did not take that deal. I mean, that 15-year sweetheart deal. I wonder why it was even offered, but that was a tremendous mistake. And if that was her decision, if the lawyers explained to her everything that was necessary for her to make an intelligent decision on that, that really gives you a little bit of insight into how Sarah Boone's mind works, which is a little terrifying. Daisy, I enjoy your channel. Thank you, and I enjoy you, Daisy, for tuning in. And Daisy says they're waiting for Sarah to finish her bacon and eggs. I don't think that was on the menu. I think she did get some other treats that they got for her. I think she got a shower last night. Actually 2 nights ago. So I don't know about last night. So good morning, Maui Swift. It's good to see you here. Blurry Lights, do you have a guesstimate when the judge will make a decision on this morning's motion? Will he wait to write a written order or tell us in the morning? Okay. He must make a decision on this motion this morning because it affects voir dire. They want to voir dire these prospective jurors about battered spouse syndrome. And if the judge is not going to make a ruling on that, they're not going to know what to do. So the judge is going to have to make a ruling on this very soon. And if he doesn't, then they're going to have to postpone the trial, and that's not going to happen. So most likely, the judge is going to make a ruling from the bench, and we should hear it. I don't think he can punt this and say, I'm going to issue a written order. I don't think he can do that. It's going to have to be an oral ruling, probably today from the bench, because after this hearing, they're going to continue with voir dire, and the state's going to go first. Plaintiff goes first, state goes first, and then after that, the defense is going to go. So, they're going to need a ruling on this today, this morning. So that's what we can expect to happen. Cammy Cat, good morning from California. Another California resident here. Good morning. It's really early morning there, isn't it? And guess what? In certain places, it's the evening. So good evening, Brother Counsel. Good evening to you. Look at this. Hello from Croatia. Truly international channel that we have here. And hello from Israel, Ronnie Gilmore. It's going to be close to the getting close to the holiday there. So hello from Israel. My sister lives in Israel. I have a whole bunch of cousins in Israel. I have some cousins serving in the IDF right now. Hopefully everyone will stay safe. Moon Goddess, good morning. Watching from Boston. Boston, a little known town. And good morning to you. And we have Kent, UK. Hello, brother Counsel. Hello, Eddie. We've got Philly here, Philly, Pennsylvania. Thank you for covering this live. We are still watching it. Don't worry, everybody. As soon as it starts, we will jump to it. So we're just here hanging out all together, waiting for it to start. Laura Long, is the video of George in the suitcase with Sarah laughing? And by the way, I always was saying his name as Jorge because that's probably the correct way that you pronounce that name. But somebody did mention in the comments, and this is probably my mistake. I make mistakes. But somebody mentioned that actually he preferred that his name be pronunciated as George. So that's why we're going to start changing it. If anybody has any information to the contrary, then I do want to respect him. So I want to call him the right way that he wants to be called. And I do keep hearing about him being referred to as George. I just thought that people are just pronouncing it wrong. But if that's really how he prefers to be referred to, then we refer to that. All right. Is the video of George in the suitcase with Sarah laughing and berating him going to be played for the jury? Absolutely. You are absolutely, they're absolutely going to hear that. So don't worry about that, Laura Long. Marsha Lynn, good morning from Oklahoma. Love this channel. I love you too. Thank you for tuning in. Fawn Fargo, Shalom Room. Love this channel. Love you guys too. Thank you. Appreciate all the love. Look at that. Hello from Coldstream in Scotland, UK. Hope you don't mind my accent. Hello from Virginia. Good morning, Aaron. Just Joe, can't wait to see Sarah's lawyer in action. Okay, well, he's got that nice southern drawl there, and that can really, some people really like that. Sometimes I wish I had a nice southern drawl when I'm talking to a jury. Just sometimes things just sound better that way. Steve Jackson, thank you very much for the super thanks. $9.99. BC, as we know, she rejected the plea deal. Question, how long does a plea deal stay on the table? And how far into this trial will the DA keep the offer open before they say, tough luck, no more deals? Great, amazing question. So how long does a plea deal stay open for? As long as the state wants it to stay open for. So the state could give an exploding offer, as they call it. They can say, this offer is only good till the end of business today, business tomorrow. We'll keep it open for another week. And it also can depend as the trial is going on, depending how they feel about their trial. I have gotten offers literally as the jury has been deliberating. So there can always be offers, always be plea deals entered into. It's never too late until the jury reaches a verdict. So is the offer open now? I don't know. And if I was the defense, I would certainly be asking that question. Hey, just want to know, is that plea deal open? And then it's still available. Is it still on the table? And if it is, then I would go to Sarah Boone and I would say, look, the deal's still on the table. Maybe as the trial's going on, first day, second day, third day, and things may not be looking so great for her. I may say, hey, maybe a good idea to take this plea deal, but she ultimately gets the decision. So I can only advise my client about whether it's a good idea or not. So we don't know how long it's open for, but bottom line is it could be open as long as the state wants it to be open for. And we'll see. It could be they're going to say tough luck. And again, I think that was a sweetheart deal. I mean, I think everyone thinks that, and nobody can understand why she would not take it unless she's just deranged, which it's possible. Fawn Fargo, judge is attending another case now, then Boone. Okay, I'm glad that you got that information. So we're still waiting. I don't know why that case. Oh, here we go. It is about to start. So we will jump to that right now. Let's do it. crank up the volume here. Sarah Boone sporting that jacket, no tie. In the meantime, we'll show some more comments here. Sam, Lizzie, really been enjoying your videos. Good luck in your trial this week. Actually, my trial starts November 4th. Appreciate all the good lucks there. Wishes. And by the way, when you're in trial, at least when I'm in trial, it is constantly on my mind the entire day, even weeks before I'm already putting myself in positions, thinking about things, thinking about arguments, thinking about cross-examinations. It literally doesn't give you any rest. I dream about it. I wake up thinking about it. It's really completely takes over my life. So when I'm in trial, I'm 100% locked in. So that's why during the trial, I'm not going to be putting out any videos, but before the trial, I'll still be able to. But once that trial starts, and it should be a short trial, by the way, it should be November 4th. It should only be maybe 3 days at max, I think. So it's just going to be a short trial, and we're basically all ready to go. We got to work out jury instructions and verdict forms. That's essentially really what we're at. I'm still waiting for the final pretrial order back from the defense in that case. It's a civil case, civil trial. And just finishing up the last trial prep on that. Maybe I'll put a few slides together to show the jury. Work on my opening and my closing. So. Here's a good question. Leela, did the defense respond to the "it can't be an accident" self-defense issue? I still don't understand how she can say it was an accident self-defense, even ignoring the BSS component. She can't. She can't say it's both. You're not going to be able to argue it's both. So if they want to go with the self-defense of battered spouse, the only one they're not going to be able to argue that it was an accident. What the prosecution is going to present is evidence that this was all an accident. You're going to hear the interrogation. You're going to hear everything that's going on. You're going to hear her say that it was an accident 150 million times. So they're going to be arguing that. Now, what's the response to that? I imagine that the response, if I was James Owens, I imagine the response is going to be that she didn't mean it. She was just trying to cover for herself, or she was covering for both of them, and she was really a battered spouse, and she was just saying that it was an accident, but it really wasn't an accident. So that's what I imagine, that it was just all a lie because she's this terrible victim. So I imagine that that's what it's going to be. But once if she takes a stand, for example, and she says accident and self-defense, that's going to be a problem. We'll see what happens. Fawn Fargo, Joel from SDS, Surviving the Survivor, a good friend of mine, is in the courtroom. He's actually there. You see him there in the background? He said judge is taking care of a couple motions from other cases, then Boone will start. All right, well, we're waiting for Boone to start. I don't see him back there, Joel. I know that he's there. Chloe's mom, BC, are you familiar with the Delphi case, Richard Allen? Yes, I am somewhat familiar with it. I covered some matters of that. But there was the specific issue with with Richard Allen's attorneys being dismissed from the case. I covered that issue, the appeal to the Supreme Court, and eventually they were reinstated as her attorneys. They're not allowing any sort of recording devices in the courtroom, so we're not going to really be to be able to cover the trial. So that's just a shame. So there's not really much to cover there. I mean, I can cover some filings, but the actual trial we're not going to be able to see. So unfortunately, we're not going to be able to really cover that trial. Meld W222. Maybe today Mr. Owens can ask if Sarah can have a daily nap. She's special. JT, good morning from Ferndale, Michigan. Good morning from Ferndale. My mom actually used to teach in a school in Ferndale. So not a very good mission statement. That's why I love this channel. Thank you. That is our mission statement. We are raising the bar in how true crime is covered.
William J. for the state.
James Owens on behalf of Sarah Boone. Tony Henderson on behalf of Sarah Boone.
I do.
Ma'am, good morning. Can you state your full name and date of birth for the record for me?
Sarah Boone, 10-10-7-7.
All right, Ms. Boone is seated at counsel's table wearing a gray suit and a white blouse. She is out of custody and unshackled. Mr. Beck, you arrived late, sir. Can I get your appearance for the record, please? All right, thank you. All right, we're here on a litany of different matters, multiple motions in limine. The state's motion in limine to exclude battered spouse syndrome evidence or exclude mention of battered spouse syndrome evidence until the defendant testifies to a justifiable use of deadly force, filed October 6. Defendant's response to state's motion in limine to exclude battered spouse syndrome evidence or mention of battered spouse syndrome evidence until defendant testified filed October 15th. And then the defendant's amended response to same, also filed October 15th. The defendant's motion in limine filed October 6th. The state's response to same filed October 6th. State's motion, objection and motion in limine to exclude decedent's medical records filed October 14th. And then the parties' objections with regard to specific exhibits that may be sought to be entered at trial. The court has reviewed everything and reviewed all of your case law, and we're ready to proceed. I believe we should probably proceed first on the battered spouse motions first. So state, you may begin. And I also have reviewed as well the excerpts of the deposition of both Dr. Warner and Dr. Harper as identified in the state's motion.
Well, there you go. So he did review everything, which is commendable because some of these were just filed last night late. So he reviewed everything. He said that he looked into the case law. He even reviewed some of the excerpts of the depositions, which we went through in the motion, the state's motion. They referenced some excerpts of the experts' depositions. So he is very, very well positioned to make a ruling. So that's great. So he's going to allow them to make a record, but he already knows what he's doing, most likely. And I'm sorry I didn't get to everyone else's good mornings from all different places and locations, but I appreciate all of you joining us today, wherever you are located. Now, apparently there was also some objections that were filed. I think this was also a late night filing last night. I didn't go through it with you, but there's just some common objections that may happen for different exhibits that are proposed to be entered. So they'll go through some of those objections as well. Other than that, I think all the other motions and everything we covered already on this channel. So you are all in the most perfect position. You are just like one of the lawyers sitting at that table who are very, very well familiar with the law and the facts and the evidence that have to do with those specific motions. So this is the best position you can possibly be in, which is why you should all be a subscriber of Brother Counsel.
Your Honor, for the record, I'm having Madam Clerk mark A, B, and C for identification purposes for this hearing. A is a copy of the defendant's statements that she made on body-worn camera to Deputy Sheriff Kayla Rodriguez on February 24th of 2020, as well as the interview that she provided to Detectives Counsel and Lowen on February 24th, 2020, and February 25th of 2020. It is an identical exhibit as to what was provided to the court for review in chambers as a courtesy before the motion to suppress statements, as well as what is entered into evidence for that motion to suppress statements hearing that was held. State would move A for identification purposes, in as 1 for the purposes of this hearing.
Responses to what was pre-marked as A.
No objection.
All right, what was pre-marked as states A will be received without objection as states 1.
B for identification for purposes of this hearing is the deposition of Dr. Harper. We would move that into evidence as states 2 for the purposes of this hearing.
Any objection?
No objection.
All right, what was pre-marked as B will be received without objection as states 2.
C for identification for purposes of this hearing is the deposition of Dr. Werner. State would move that into evidence as states 3 for the purposes of this hearing.
Any objection? All right, what was pre-marked as states C will be received without objection as states 3.
Your Honor is familiar with all those exhibits and has been able to review them prior to the hearing, so I will just proceed to the legal argument.
You may proceed.
Your Honor, this is a motion to eliminate. We are asking for a pretrial ruling based on the proffered statements that the defendant has made, which should, in good faith and reliance, the state should be able to assume that that will be her testimony at trial, given that her latest version of events was just given to our expert last week. So we are asking for a pretrial ruling on if that is the evidence that comes in at trial, will she get a self-defense instruction? Will she be able to then open the door to all the things that come with self-defense, such as reputation evidence of the victim for being violent, which she may or may not be aware of, that's not required under the law, or prior instances of violence between she and the victim, or the victim and anybody that she is aware of, because that goes to the reasonableness of her perception of an imminent threat of death or great bodily harm.
Right. So as we spoke about, reputation evidence is generally not admissible. It's character evidence. Character evidence is not admissible. But when you argue for battered spouse syndrome, then and self-defense, then all of a sudden, then that becomes very relevant. His reputation, prior instances of violence, things like that. So that's all going to depend on if the judge is going to allow her to argue battered spouse and self-defense.
We are not asking to not be allowed to talk about these things during voir dire. The defense cited numerous cases and spent some of their time in their response about the ability to voir dire that. That was not the purpose of our motion. I don't think we mentioned voir dire.
Well, they did say that they don't want any mention of battered spouse syndrome. I mean, they did say that, but it seems like they're changing their position right now, which sometimes happens.
Because we understand that the defendant can, like any other witness, change her story again. So we understand that we both, on both sides, we intend on spending a great deal of time on it as well for the state of Florida. We need to explore these issues during jury selection. But what we are asking from the court now preliminarily is, if that is what the defendant is going to say in trial, and I'm not asking the court to make any credibility determinations about one version or another. We're asking you to treat this just like a C4 motion or a motion for summary judgment in a civil case. If this is what she says, does this amount to what they are asking for legally? And it's the state's position under the case law that no, because under her statements that she gave to the experts, there was no overt act taken by the decedent on that day. There was no overt action. And that's what's required under the law to trigger her response of acting in self-defense.
So when he's talking about this motion for summary disposition, like similar to that, a C4 motion or a motion for summary disposition, he's talking about that there's some times where there's two different types of motions for summary disposition or summary judgment. One of them is that even if we were to accept everything that the plaintiff is saying or that the defendant is saying, even if we were to accept everything that they're saying, they still don't actually have a cause for their specific defense or their specific case. So he's saying, even if we were to accept everything that she told to the experts in this case, still it doesn't equal self-defense because there was no overt action taken by George. If there's no overt action by George, then that she cannot possibly act in self-defense. So that's what he's arguing.
There was nothing creating an imminent fear of death or great bodily harm to her until she committed 2 forcible felonies and a non-forcible felony. What her testimony is we were having a good day. Now, what's different, and again, we're not asking you to make a credibility determination about what's different, but what is different than what you had heard at the motion to suppress is we were having a good day, but I'm on edge every day because of past instances of violence, including an instance the night before. But we were having a good day. We're out on the porch. There's a dartboard out there. There's puzzles that we're doing. We're doing arts and crafts. We're doing everything to keep him preoccupied so he doesn't get sad or upset. Interjecting with some phone calls to his family, which she knows would potentially upset him, but that's her testimony. And then eventually it comes to a point in time where they're sitting on the couch and he reaches over to her and says, "Tag, you're it." And she apparently runs up to the shower to hide, and he apparently gets into the suitcase to hide, and it's not clear who's it. Eventually she comes down out of the shower after she sees.
Sorry. I'm sorry. I just have a special place in my heart for snark. So when he says something like that, like sarcastically, so it's not clear who's it, I'm sorry, but that's pretty funny. Because really that's not how you play tag. Tag is not hide and seek. But okay, I'm sorry.
She says she was getting cold up there and sees him in the suitcase and zips him up. And at the time that she zips the suitcase, what she describes as nearly entirely shut, but 2 fingertips could get out. Mind you, a 103-pound man, 2 fingertips. They're laughing. It's all fun and games still. There's still no overt act taken by the decedent during this entire calendar day to put anybody in reasonable fear, objectively reasonable in fear of imminent harm, great bodily harm or death. And it's only when he begins to say, after she has zipped him up into the suitcase, again, she is saying that she did not have malintent at that time. When he starts to say, "I cannot breathe," now she describes to the doctors that she does have bad intent, and she wants him to feel what she has felt in the past. She gets angry, is her description. She shakes the suitcase, she beats it, it falls over, it flips over, he sticks his fingertips out, she hits him with a bat. So she's now the initial aggressor, and we'll discuss jury instructions as we get closer, but she's the initial aggressor, and she has now committed forcible felonies, aggravated assault, and aggravated battery, stating that I only intended to keep him in there for a couple of minutes. I believed he could get out. She never perceived, according to her, that he would die or face great bodily harm. And she just goes upstairs knowing now he's mad because she won't let him out. Now, because of the actions she took as the initial aggressor, she is facing death or great bodily harm from the decedent if he gets out. And she completely expects him to get out because her testimony is that he could get 2 fingertips out of the zipper. So, Your Honor, under the law, the state understands. We are deeply, deeply thoughtful about this request because of the risk of error, but
Which is most likely why it's not going to get granted, but okay.
this is just one of those cases, like the cases the state cited. There is no self-defense if that is what her testimony is. And therefore, the jury should not hear about any prior instances of violence, any reputation evidence, any battered spouse syndrome, unless and until there is testimony that is self-defense that's recognized under the state of Florida's laws. So what we are asking for is a ruling that if, and this is a motion in limine, and a motion in limine is, hey, this is what's proffered to the court prior to trial. If this is what comes in at trial, this is the court's preliminary ruling, unless something changes. What we're asking for is a preliminary ruling that if that is what her testimony is, then we should not be allowing introduction of past instances of violence, reputation for violence, or battered spouse syndrome evidence. And furthermore, what the case law supports is our request that clearly this evidence can only come from her. There was nobody else in the apartment or townhouse that night. So she should have to testify before any of those things come in. And her testimony should meet the requirements of an overt act before any of this testimony comes in. It should not be allowed to come in prior to her testimony. And under the case law that the state cited, it's not unfair. It's not forcing her to testify. She chose to raise battered spouse syndrome. The state completely understands we have the burden of disproving self-defense beyond a reasonable doubt. But what the case law says is we shouldn't have to combat this. We can't put the toothpaste back in the tube until she actually puts forth the self-defense that justifies all this. So that is our request. We're not making any requests about voir dire because we understand she can come in and testify differently yet again at trial. And that's a discussion we'll have to have as well about how that will occur. The state's position is that if she changes her testimony yet again, she should have to give a narrative testimony. No attorney should be allowed to participate in putting forth new testimony about the events of February 23rd. Thank you.
All right, thank you very much. Response.
And by the way, I hope nobody minds, but I just put it up to a little bit faster than what they're really going, just 1.25. So if it's
morning,
really
Judge.
too
Good morning,
fast for anybody, just let me know.
I'm a little confused, but I want to make sure, so probably can save some time here. My understanding is what the state's saying at this time, that there's no objection to raising this in voir dire to see how the jury would react or their feelings about it. So that's not it. So what that leaves me is, I guess the state's trying to say there should be no mention of battered spouse or anything like that in opening statement.
That wasn't my takeaway either. My takeaway from the motion and the state's argument today is from a evidence perspective, concepts or testimony or even opinion evidence about battered spouse syndrome cannot be raised, including any of the reputation or specific instances of conduct that are contemplated by self-defense until there's a factual basis for it. My understanding of the defense's Dr. Harper's deposition is that the basis of her opinion, and please correct me if I am wrong, but my understanding is that the basis of Dr. Harper's deposition is based on her 4 or 5 interviews or sessions with Ms. Boone as to what transpired on the day and night in question. Is that accurate?
I need to confer.
Sure.
Well, if the judge gives you any clues about what he's going to rule, now it sounds like he is almost seems like he's going to rule against the defense.
Judge, if I could have you repeat that question.
Sure. So my understanding, well, let me ask you, I'll have a more of an open-ended question. What is the basis factually of Dr. Harper's opinion? So if we were at trial right now for the purposes of this exercise, and you were going to call Dr. Harper to testify, what is the factual basis component under 90.702 in order to get her to testify? We're not dealing with her CV, her credentials. I'm not sure the state's going to have any position with regard to those, but let's just assume the state has no objection with regard to her credentials and that she is in fact an expert based on her knowledge, training, and experience in her field. What is step 1 under 90.702 to allow her to testify? What is the sufficient factual basis of her opinion?
Judge, I think her opinion would be based on several different things. Mainly, one of the things that her opinion would be based on is her interaction over the course of time with our client, Ms. Boone. That's one. But Dr. Harper has also reviewed other evidence in this case that helps her form the basis of her opinion, and also her knowledge of battered spouse syndrome. That has to be taken into account because, quite frankly, Judge, people who suffer from certain things, they don't know. That's why you have to, like, if you have to get an expert opinion as to someone's.
By the way, I do want to say a special thank you to Brooklyn, Janet, and this is a very good point. You know, maybe they'll start the same way they have like this trunks in the back of people's cars. They have a device where you can get yourself out. So maybe because of this case, you know, lawyers out there, they work to change these type of the way that these things are made. So maybe this will be a new safety precaution that they will take. And also, I just wanted to recognize Kim Hastings, a very wonderful supporter of mine. Good luck with your upcoming trial. Take care of yourself and enjoy your holiday. Thank you very much for that, Kim. Let's go back to the hearing.
Mental health situation. I mean, a person doesn't really know that they're suffering from a mental health problem. They have no idea in a lot of circumstances. What they do is they get evaluated by a doctor. The doctor has experience of what signs to look for in these things. And
Again, the question was, what is the factual basis? Tell me facts of what happened, not just how wonderfully qualified Dr. Harper is. What's the factual basis for her conclusions and her opinions? That was the question, and he's kind of beating around the bush.
getting those signs with what they told and outside sources too. They are able to make a determination based on their training and experience. So,
But based on the Okendo case, which is cited by the state as to what battered spouse is it's an ambit of self-defense. So under the statute, are you traveling under 776.012 as your basis for self-defense?
yes, but this is the problem that I'm having here. Self-defense is a defense. It's an affirmative defense that's available to anybody. It's based on the evidence at trial.
But what's the overt act? Because in reviewing Dr. Harper's deposition, there were specific questions by the state inquired of her about the language, specifically in those statutes, about the imminence of fear. And she was unable to answer those questions. So my question really is, what's the overt act?
See, we didn't have the deposition, so we couldn't look through this deposition and see what questions and answers were given. So we're kind of flying blind. So we're just going to have to trust the judge for what he said, that Dr. Harper was asked these questions about an overt act. If you're acting in self-defense, that means that somebody else had to have done something to make you feel that your life is in danger. When Dr. Harper was asked that question, it didn't seem like she gave an answer. And that's what the statute requires. So perhaps they're not going to be able to argue self-defense now.
By the victim, which would have given rise to self-defense. Because the case law, taking aside the state's case law under the stand your ground concepts, which I find distinguishable, because under 776.032, there's a specific statutory scheme for pretrial stand your ground motions. So I find those cases distinguishable for that very reason. But there's specific case law, bless you, there's specific case law that talks about in the self-defense realm that the state has cited to in their motion that an overt act is needed. What is the overt act?
Judge, the overt act has to come from testimony, and I agree in this case, but that has to be the testimony of Sarah Boone for that overt act. And that testimony can only take place at trial. In making a determination of whether to give the self-defense instruction, it has to be based on the evidence presented at trial.
I agree with you on that. I completely agree with you on that. And the case law is clear that if even there's a scintilla of evidence, I have to give that instruction. But we're not dealing with the jury instruction right now. What I'm dealing with right now is pretrial. The state saying you cannot proceed on battered spouse. There's two avenues in this motion. Avenue one is you cannot proceed with battered spouse because of the factual reasons based on Dr. Harper's deposition as to what she's going to be the basis of her opinion. Battered spouse cannot be entered. Alternatively, you cannot talk about it until there's foundation. That's my takeaway from the state's argument, that before battered spouse is argued or provided or opinion, there has to be that foundation to it. And the linchpin for me is the overt act issue. That how can we have anybody testify to opinions or any of the reputation or specific instances of conduct that we permitted until that overt act is established? What's your response to that?
My response to that, if I'm understanding you correctly.
If you need to reframe the question, please.
Because it's procedurally. There's no way that we could come in here and put Dr. Harper on the stand before Sarah Boone. It just doesn't work, because to even establish the relevancy of Dr. Harper's testimony, Sarah Boone, who's the only witness there at the time, I agree with that with the state, has to present evidence of self-defense, has to present the evidence of the court talking about that overt act. It's not based on what the doctor perceives or what the doctor was told by Ms. Boone, or what questions were asked at that deposition. I don't know. Mr. Owens took the deposition. The questions, though, at the depositions are limited and the doctor answers, but that's not what this has to be based on. What it has to be based on is what does Ms. Boone, in this case, testifies to on the stand. And if any of that excuse me, if any of that presents a scintilla of evidence to award the self-defense instruction, then the self-defense instruction should be given. That's the first step. Everything follows after that, Judge, because this isn't a situation where I think it's appropriate to make a pretrial ruling, because the ruling has to be based on the evidence that comes from that witness stand. Now, any of the evidence is subject to cross-examination, impeachment, anything like that. But that's a wait for the jury to determine. But as to the admissibility of the evidence, it has to start with Sarah Boone. A judgment can't be made or a decision cannot be made until the testimony of Sarah Boone takes place at trial. This is just procedurally incorrect.
Any other arguments, sir?
No other argument.
Thank you. Rebuttal.
This is procedurally correct. Parties are allowed to get motions in limine based on the proffers of evidence that have been made prior to trial. Apparently, opposing counsel has not read the depositions, or he clearly didn't attend them because he was not there. But the court has before it the statements that Sarah Boone made when directly asked, what happened that day? What happened next? And there was no overt act taken by the decedent on that particular day. What they want to do, and what is not permissible under the case law that I've cited, in particular the one that says you get a threatening text and then 2 days later you can't go slit somebody's throat because of the threatening text 2 days earlier. Not to dehumanize Mr. Torres at all, but to give you this analogy. If somebody owns a bad dog and that bad dog bites and that bad dog is bitten in the past, but on this particular day, the dog is just doing arts and crafts and puzzles and hanging out, drinking some Woodbridge Chardonnay, and you put the dog in the suitcase, and then the dog barks because it's in the suitcase and doesn't want to be in the suitcase when it's zipped up. That triggers you to, I remember when the dog bit me in the past. You can't, that's not how.
Again, it comes down to one issue, and there's a lot of talk, and lawyers do this all the time. But really, the judge is sitting there patiently. He understands this. It comes down to one issue. The evidence that was proffered, meaning what we know now about the upcoming evidence. Is that enough to say there's no overt act? All of the proffered evidence does not point to George doing anything to put Sarah Boone's life, or to put her in fear of her life, or great bodily harm, or not? Does there have to be that proffered evidence is not enough? There actually has to be evidence that comes out on the witness stand, and then they have to wait. That's what it comes down to. So all this talk about, he could be the most wild guy and dangerous person before, but today he was completely normal, and therefore there's no evidence of anything, that he was committing an overt act. Really, the question here, is the proffered evidence enough to argue that therefore the judge should not allow battered spouse syndrome?
How this works. That's not how self-defense works with or without battered spouse syndrome. There has to be an overt act. You can't bootstrap and make up a fictitious act of violence on that day based on the past violence. That's not what the case law allows. And the state is asking, unless they are saying that the testimony will be different at trial, we are asking for the court to prevent them from saying anything about this during opening statements, because they will know based on the court's ruling what your client has already said to Doctors Werner and Harper does not admit self-defense evidence into this case. So that's what we're looking for, is that ruling. If this is what the testimony is at trial, then self-defense is not going to apply, and all the ancillary prejudicial things that come with it, reputation evidence, past instances of violence, battered spouse evidence, is not coming in either.
Then why would you be allowed to talk about it during voir dire either? Why would you stop there? Just say you can't argue it in opening statements. If you can't argue in opening statements, then why should you be allowed to talk about it in voir dire? That's just going to confuse the jury. But he's stopping at voir dire for whatever reason.
Now, if they make some statements and promises that they cannot fulfill in opening statements, then that'll be on them. King versus State will allow us to point those things out to the jury, and it will not be burden shifting. But that's what we're asking is, this is a proffer, just like any other proffer testimony, like a sex crimes case, where we file a deposition of a Williams Rule victim and ask the court to rule prior to trial, hey, if this is how the Williams Rule victim testifies, and it's clear and convincing, and it meets all the standards under 404 and 403, can this prior act of sexual violence come in during the trial? This is what parties do all the time, is get pretrial rulings on crucial matters like this. This is a crucial matter because the tip of the iceberg is the second-degree murder. The rest of the iceberg, the 99% of what has been going on for the last month and a half, is the self-defense that just isn't there. It wasn't there under her former statements to the police, and it's not there under her current statements. So we're asking for a ruling, a motion in limine, which is subject to change based on the evidence at trial. But if this is what the evidence is at trial, the
Ooh, that's a very important part. He just gave the judge an out, which is something you always want to do. He's letting the judge know, you can rule in my favor and then change your mind in the middle of trial. That's fine. Motions in limine just say, at this point of the trial, we're not going to allow it. If something changes or develops, then we can revisit it. And that always gives the judge an out, which can convince him to rule in your favor.
court should not allow any of the battered spouse, any of the prior violence, any reputation evidence in. That's all we're asking for.
Okay.
Thank you.
All right, thank you.
Judge, can I respond?
Briefly.
Judge, it is not the responsibility of the defense to present their case at a pretrial hearing. However,
But the problem is in the state's argument, in the case law, which the case law has been presented by the defense in your filings are not germane to the issue. We're not addressing jury selection and the standard of proof and the burden with regard to self-defense, you establishing a prima facie case, and then the higher standard that the state has to overcome it. There's no dispute as to that. The issue is the necessary predicate to establish battered spouse.
The foundation, the necessary predicate. That's what is the question. Do you have to lay some sort of foundation before you start arguing battered spouse?
And the state's argument is that due to the lack of an overt act based on what Dr. Harper has relied upon, to wit, the multiple interviews or sessions with Ms. Boone, that element seemingly is lacking. We all know what elements are, right? If it's a negligence case, it's duty breach causation. In this case, it's the elements based on the jury instructions are George Torres is dead, she caused the death, and it was done so in a depraved heart manner. I may have butchered that last element, but those are the elements that need to be established based on the jury instructions. Similarly with self-defense, the case law talks about the overt act.
Yeah.
And the flashpoint of the defense's argument is that the facts which were provided to the expert, who in turn will testify to battered spouse, that flashpoint, that overt act is lacking.
It's not, Judge, but I find myself in the position now to disclose what our view of the overt act is.
Okay.
That's what this is what this motion has put us into. So it's an exercise of the state to learn our theory or our view of the evidence, because the overt act is in the physical evidence. And the overt act is mentioned to Dr. Harper in the deposition.
Well, then if it's mentioned in the deposition, then say it. They're not trying to learn from your case anything that's not there already. That's what you just said. You said it's in the deposition. What was in the deposition? Where? Point to me in the deposition where there is an overt act. And now you can't argue that, oh, they're making us try our case now and they're going to, we don't have the element of surprise anymore. That's a little bit of a blunder right there.
As to the reaction of Ms. Boone by the overt act. And the overt acts, I have to tell you, his hand is coming out of the suitcase. That means.
Well, there you go. His hand coming out of the suitcase is the overt act. That is what made Sarah Boone fear for her life, by his two fingers coming out of that suitcase.
She's about to get out of the suitcase. Now, based on history and everything else, she doesn't have to wait to see what's going to happen when he gets out of the suitcase. It's clear what's going to happen when he gets out of the suitcase. It's followed up by physical evidence, because there's a picture provided of Mr. Torres's hand that shows a mark on that hand that it matches up with the bat. That's the overt act. It's like a gun, okay? You don't have to wait for them to pull the trigger. You don't. And it's based on all the evidence in the case, just not testimony, but also physical evidence that might support the testimony.
Thank you, sir. All right, the court has had the opportunity to review the motions, review all the case law. The state's motion is going to be granted in part and denied in part. With regard to the state's request to exclude battered spouse syndrome evidence outright, the motion is denied. As to specifically Wagner, for the reasons identified in the court's prior rulings as to the concept of argument, again, there's no outright evidence of accident, not argument, excuse me. As to the state's reliance on Lantz, L-A-N-T-Z v. State, 263 Southern 3rd, 279, no argument of self-defense was ever offered in that case. I find the cases of Reed v. State, 213 Southern 3rd, 1110, Rudin, R-U-D-I-N v. State, 182 Southern 3rd 724, State v. Woodson 349 Southern 3rd 510, and Morris 325 Southern 3rd 1009, distinguishable as all of those cases were traveling under 776.032 for stand your ground hearings. It's undisputable that an overt act needs to be provided under the Holland case by the Florida Supreme Court, 916 Southern 2nd 750. I find the departure from the essential requirements of law argument by the state factually and legally distinguishable, as there was a specific statute for the state obtaining medical records as relied upon in Roberts v. State by the 6th DCA in May of 2023 WL 3262633 at pinpoint site 2. So for those reasons, the state outright motion to preclude or exclude battered spouse syndrome evidence in toto is denied. With regard to the second portion, that excluding mention of battered spouse syndrome evidence until there's a basis for it, the court's going to rely on Ladd and Medina, specifically that there needs to be testimony provided for the expert to testify to the battered spouse syndrome, and there needs to be sufficient predicate established for that self-defense. So I'm going to preclude any mention or testimony in the form of expert testimony as to battered spouse until that necessary predicate as identified in Ladd 564 Southern 2nd 587 has been established. Any questions with regard to the state's ruling? I'm sorry, the court's ruling, forgive me. Defense.
Meaning,
You want to mention an opening? You can mention an opening. Certainly, I'm going to allow you, and the state at this point has no problem with the concept of battered spouse being addressed in voir dire. And even if the state objected to it, I most likely would overrule it based on the litany of case law that you cited, that you're allowed to dive into those things during jury selection. As to should the defense put on a case, the predicate under Ladd needs to be established before any expert opines to battered spouse.
my concern is open. Can it be mentioned in?
Yes, that's your decision. That is your decision if you want to mention an opening. There's no preclusion from you doing that. Okay. Any other questions with regard to the court's order on that matter? State.
No, Your Honor.
Defense.
No, Your Honor.
Okay, thank you.
Okay, well then a win for Sarah Boone. They are able to argue battered spouse syndrome in the opening statements, but they can't do any more mentioning. I mean, they can't have the expert talk about battered spouse syndrome unless there is a proper foundation laid, which can only come from Sarah Boone, which means that Sarah Boone is going to have to take the stand before the expert testifies about her battered spouse syndrome defense. Now, in the meantime, let me just get to a few comments here. KUC Mag, I'm sorry if I'm butchering your name. Thank you very much for the super thanks here. And where did this other lawyer come from? She has two lawyers now, or did Owens leave? No, Owens is still there. Also, how nervous do you get before opening statements? She has Owens. I believe that this other guy who was just arguing, I don't know what his name is. I'm sorry. I don't mean any disrespect. I don't know what his name is. But he was with this Owens. I think early on, I heard him arguing some motions. So it could be that he either works with Owens or maybe not part of the same firm, but he's been on the case, I think, also for a little while. And then some other attorneys also, I heard, are going to be helping them out as well. So no, Owens is still on the case. This other guy's on the case. I just forget his name. How nervous do I get before opening statements? Quite frankly, when I first started trying cases, I was much more nervous than I am now. Now I enjoy it probably more than I should. And therefore, of course, you do get some nervous. You always get some butterflies. But once I get up there and I know my case extremely well, I have my notes, I have my slides, I am just ready to rock and roll. So I don't really get as nervous as I used to be, but I love it. Maybe I just enjoy talking to people. I enjoy talking to the jury, and I've already spoken to them during voir dire. So opening statements is just some basic butterflies that you always get. But I'm ready to rock and roll by opening statements. It's an exciting thing. I love talking to the jury. I love it. So opening statements, closing arguments, I enjoy it. All right, let's continue on to the other motions.
Moving now to the defendant's motion in limine filed October 6th and the state's response to same. It looks like we've reached some level of common ground with regard to that motion. The court is going to grant the motion with regard to the statements on page 69 through 71 of the transcript of the February 25, 2020 interview between Detectives Lowen and Counsel and Miss Boone from page 69, line 6 through page 71.
So that was about, remember those statements that she made about using the restroom at one of her neighbors, and that neighbor's so mean to her, and the state didn't want it in, and the defense were fine with not, or the defense didn't want it in. The state says fine. I don't really care. And even when I was analyzing that motion, I said, I don't think anybody's going to care about those statements coming in or not. So I was right about that. But now let's move on to some of the other statements that they're talking about.
That will be granted to the state not objecting to same. That leaves us to the statements on page 53, line 11, 53, line 13, line 14, page 55, line 24, page 56, line 1, and page 92, line 15. With that, defense, you may proceed with any argument. Similar to the last motions, I have reviewed all of y'all's case law. Okay.
The rule of sequestration applies to testimony of other witnesses, not to anything else.
Response?
I can't really hear what they're talking about. Something that's to do with sequestration of witnesses. I'm not sure what they're talking about right now. In the meantime, Aaron E., thank you very much for that. Super thanks. They say that George got mad once Sarah wouldn't let George out, but there's said no claim that George threatened Sarah once he got out of the suitcase. Well, I don't think he got out of the suitcase. But yeah, they do say that that George was mad. Obviously, he would be being locked in the suitcase. The question is, by his two fingers coming out, was that an overt act, like a gun, that now Sarah should be scared that he's going to come out of that suitcase and kill her? So that's going to be the question there. Thank you very much, Aaron.
I said there's no state witnesses.
So that's a no. May proceed with any argument, Mr. Owens. Yes, sir.
In the meantime, we have another super thanks for Aaron. Thank you very much. Getting mad and threatening someone.
I have reviewed the 2.8 instruction prior today. Thank you, Counselor.
There still has been no claim that George threatened.
They filed the response. They didn't include the highlighted portion that's italicized at the beginning. Police opinions and statements regarding guilt are generally inadmissible and must be redacted from recordings introduced into evidence unless redaction would render the defendant's relevant admissions incomprehensible. If a recorded interview cannot be appropriately redacted, the trial.
This is talking about the statements that one of the police officers made in interrogation, where the police would say, you did this, you're responsible for this, right? So he's arguing that therefore that's a conclusion of law and it should be stricken, not be allowed to be shown to the jury. We explained this on our channel, some of the previous videos, and we explained why most likely the judge is not going to grant this part being stricken, because just saying that you're responsible for this doesn't really mean that she's guilty of second-degree murder. Doesn't mean that she can't argue self-defense, which is what they're arguing after all. So the fact that she's saying that the detective is saying you did this, she should say that's right, I did this because I'm acting in self-defense. So we'll see. I think the judge is going to deny this motion.
Judge must, upon request, give the following limiting instruction immediately before the recorded interview is played for the jury. That section, which is comments directed to the court, was not placed, to my understanding, in their response.
Okay.
Little stop here just for Nan, because I haven't seen Nan in a while. Nan, where have you been? It's nice to see you back. Thank you very much for the super sticker here. Thank you for raising the level of discourse among YouTube channels covering criminal cases. That is the plan here. That's what we try to do. We're trying to raise the bar for true crime across all of the law tubers, and we're trying to make everyone raise their game, do some more research, do some research into the statutes, the case law, break it down, explain it to people. And yeah, so I'm trying to raise the bar, and thank you for appreciating that. And I need all of your help to do that. So thanks. Let's go back to the actual motion.
Any other argument?
Judge, this was a 2-hour interrogation that occurred the day or two after the event. And the day prior to this time, or that morning, the detectives uncovered the 2 videotapes, the 2-minute video that Sarah Boone had recorded, and then followed up 11 minutes later with a 22-second video that she recorded and they found on her phone, which I believe from the interrogation discloses that Sarah did not remember making those recordings. But the purpose of law enforcement's position about having her come in was to interrogate her in an attempt to get a confession from her to the murder. They spent 2 hours trying to do
That's exactly what interrogations do. They try to get you to admit to the crime.
that any which way they possibly could. And the law says that they're allowed to use, and I cited several cases. I cited the Smith v. State case, the ODEH v. State case, and the Eugene v. State. And in those cases,
I didn't see a citation to Eugene. I mean, Eugene's included in ODA, but I don't,
Eugene is found, do you need the site?
I have it. It's included in ODA, but you did not cite it in your motion.
Okay. Eugene is 53 Southern 3rd, 1104. But law enforcement are entitled to use a variety of interrogation techniques to try to elicit a confession to the crime. But as in that case, in spite of the detective's efforts, Sarah Boone refused to admit that she was guilty of the murder. But as a last resort, Judge, and it was a 2-hour interrogation, it was the last portion, at least the last quarter, it may have been less than that, is when the detectives made some statements that are highly prejudicial to the defendant and tend to be opinion and tend to invade the province of the jury. And that's why this special jury instruction 2.8, recorded interview, effective law enforcement statements on the defendant, has that italicized portion in there. And the statements we're referring to under my motion, the second section of evidence to be excluded, page 53, line 11, well, he's dead as a result of your actions. And then paragraph 9, line 13, he's dead as a result of your actions. She responded, line 14, I understand that. And then paragraph 11, page 55, line 24, I have one last question. I mean, you realize you're the person that killed him, right? Sarah Boone responds on page 56, I thought about that. And then lastly on page 92, well, intention or not, here's the detective distinguishing how he interprets the law and her culpability. Well, intention or not, George is dead, and you act like when you say unintentionally, that absolves you from everything. That is exactly the kind of opinion testimony from law enforcement that the courts are worried about. The probative value of that type of opinion testimony about her guilt is outweighed by the prejudicial effect. Thank you.
Response.
State stands by the case law that we cited and that the jury instruction that would be read. I didn't feel it necessary to include italicized portions of comments to the court because this is what would get read to the jury. Those statements are designed to get responses from her. They did get responses from her.
Let me ask this question first, Mr. J. Do you disagree with counsel's representation of what is reflected in the Q&A at that point in time?
To the extent
Okay, that is a hint. That is a hint by the judge saying, yes, say that you disagree, because quite frankly, like I explained, there's nothing wrong with the way that he asked. He's not incriminating her. He's not saying that you violated the law, that you're second-degree murder, that you're guilty of it. He didn't say that. They're talking in regular interrogation. So this would be a hint by the judge that the prosecution say, yes, I don't agree with what James Owens is representing the detective is actually doing.
that he is making the argument that they're expressing an opinion about
No. The words, not his opinion, not his thoughts or what it means, but the black and white verbiage is reflected in the motion. Is that what's reflected in the recording?
I'm accepting that he would not misrepresent.
Oh, okay, so now he's asking, okay, is that exactly the words that he said? Which, yeah.
Okay, thank you. You may continue.
And as far as the last
See, even I make mistakes. I thought he was asking about your opinion about what he meant with that. So I apologize for that. I am not above making mistakes myself.
line on page 92, line 15, if something's designed to get a response that a normal person would respond to and there's no response, that still makes it a relevant statement. He's not giving an opinion on the law. He's giving an opinion about her reactions to this interview and trying to get a reaction from her when she says, well, intention or not, Jorge is dead. You act like when you say unintentionally, that absolves you from everything. He's not stating that that is a legal defense. He's just commenting on what has transpired in the 92 pages of the interview. So we defer to whatever the court's ruling is.
Okay, thank you. Any rebuttal?
Just for the state attorney not to put that in there, the italicized portion where Supreme Court is giving instructions to the court with those comments. For them not to put that in there, I disagree.
Okay, well, the Jackson case speaks for itself and the court has reviewed it.
Thank you.
All right, thank you both for your motions, your responses, and the case law. The court is going to grant the defense's motion. I disagree with the defense, or with the state rather, as identified in their response, that the only issue is battered spouse. The issue is one of the elements is cause, and those three statements go specifically, I believe, to opinions as to the cause of Mr. Torres's death. So the court is going to grant the state's motion, as under the Bush case cited by the state, law enforcement's opinions are inadmissible due to the prejudicial effect that they may have. And I do find that this is expression of law enforcement's opinions as to the guilt of the accused. As such, the motion is granted, and those will need to be redacted from. I apologize. Thank you. The defense's motion is granted for those reasons.
Wow. Well, I am surprised. And again, I stand corrected because I don't think that those were statements that were made in law enforcement that has any opinion about the law. It's opinion about the factual scenario, what happened. I don't think it's an opinion about the law, whether she's ultimately responsible under the law for that. But the judge disagreed, and he cited some cases. And if I wasn't live right now, I'd go look at those cases and see whether I agree with his interpretation of them. But here we go. Another win for Sarah Boone. So look at that smile that she's got on. They're doing some winning. And let me show another comment here from Aaron. Again, thank you very much for your generosity today, Aaron. This is, I think, the third super sticker, so I appreciate that. Sarah said herself that she left finger room in the zipper specifically so that George can get out. So that's why she left the room, so that he can put his fingers there. Not left the room, left him in the suitcase because she assumed that he was able to get out. And now that he puts his fingers to get out, now all of a sudden you're terrified for your life. Which one is it, woman? So that is a great point by Aaron. Thank you again for the super sticker.
Any questions or clarifications with regard to the court's ruling? State. Questions or clarifications with regard to the court's ruling? Questions or clarifications with regard to the state's ruling? Or the court's ruling, excuse me. All right, that takes us now to the state's objection and motion in limine to exclude decedent's medical records. I've reviewed that as well. State, you may proceed.
Judge, just the other night, I received 550 pages of medical records regarding the treatment of Mr. Torres from two incidents, one in 2017 and one in 2018. The third email that I received from Mr. Owens purported he believed that they had attachments. They did not. I replied to him as such, and I've not gotten any additional emails with attachments regarding the medical records. So for the purposes of this hearing, all I'm arguing about is the 550 pages that I have been provided. One of those instances involved a narrative being given by the patient, Mr. Torres, that he had put his hand through a plate glass window.
This is the 2018 incident, correct?
Yes.
Yes.
And his wife, the following day, made him go in and get treatment. There was a 4.5 centimeter laceration that required 2 sutures. There is no history in the narrative about any violence that the decedent had committed. So I anticipate that Ms. Boone, when she testifies, will give us an explanation about how this was an instance of past violence that she was aware of by the decedent. So making that assumption, then what the state is asking for is the 57 pages seems excessive. This jury is going to have a lot of information to weigh and consider. Not every page of these 57 pages is relevant. What is relevant is, yes, he came in for treatment, that narrative, and the history that he gave of putting his hand through a plate glass window and that he got sutures, that corroborates her testimony. I understand why she will need corroboration for her testimony to bolster her credibility. So if she testifies that way, we get it, but it's just excessive and it's going to be confusing. They don't need to read 57 pages of all of his treatment. The second batch was 487 pages regarding an incident on Christmas of 2017, when what the decedent reports in the narrative to the hospital is that some unknown men jumped him and beat him up. Being a victim of violence is not relevant in this case. I expect there will be a story based upon the testimony that we've taken from the experts that this all happened at a family gathering, and one of the decedent's brothers learned from Sarah Boone that Sarah Boone said that the decedent, had committed violence against her and then beat him up. That's not the same ilk as corroborating violence with breaking windows or whatever it is that caused his laceration, whatever she ends up testifying to about the 2018 incident. But this incident it's irrelevant that he got beat up by his brother. It's irrelevant that he suffered the amount and severity of injuries that he did. That is not required to corroborate her testimony that, I don't even know if it comes in, that she makes an out-of-court statement to the decedent's brother that something is true that happened in the past. That seems like classic hearsay. I'm not sure how she would get that in. I don't know that the 487 pages is needed to corroborate that. And if the court, like I stated in my response, if the court believes that it is necessary to corroborate her story that he did get beat up by his brother, then again, there are narrative parts of these medical records. Generally, I would say in this particular instance, it was a handful of pages that give the narrative as to what happened. And I don't know that it's relevant what the treatment was that he received, but there's narratives of that as well. They don't need to be bogged down with 487 pages of toxicology reports, nursing rounds, just all the things that I'm sure the court is familiar with from your past experience that are in these medical records. It's unnecessary and it's prejudicial. Its probative value is substantially outweighed by its prejudice, confusing, repetitiveness, as I outlined in my response. So that's our position.
Thank you, sir.
Okay, so too much, too cumulative, too confusing to the jury. It's a classic 403, so he doesn't want that. I just wanted to also thank Aaron again for another super thanks. Defense claiming that the overt act was George attempting to get out of the suitcase is insulting. It's infuriating. Certainly can be. All right, let's see what the response here is by James Owens.
Response.
Judge, as you know, we got on this case about 45 days ago, and I can't tell you how many pages of discovery there is that we've had to go through. And 2 or 3 weeks ago, the state attorney provided us over 500 pages from either telephone calls that my client was involved in from the jail or tablet communications, which are kind of like emails or text messages. And that hasn't been narrowed down, but that was given to us. So that's something else we had to stop and go through over 500 pages. And they haven't narrowed that down to which ones they believe were incriminating to her.
Understood. Respectfully, that's not the issue before the
I
court right
understand
now.
that. But yes, the medical records are going to be narrowed down. And yes, we would have to make some tie to Sarah Boone's testimony to whether or not their medical records of the decedent, George Torres, are admissible to corroborate her stories about the incidences of violence and whether they match up. But yes, I agree there's going to be a narrowing down, but it's kind of premature about that. They've got several volumes. I assume before they introduce something, they're going to have to narrow it down. Did y'all not have George Torres' medical records prior to me sending them to you? All right, well, we took the deposition of Dr. Harper. And as you know, Judge, these forensic psychologists, when they're trying to make an opinion as to battered spouse or whatever the case may be, they rely on their assessment involving the personal contact and interviews they have with the client. But a lot of it is any other collateral evidence that tends to support it. That involves arrest reports, that involves court records, that involves psychological notes, that involves medical records. And at that time, when the state took Dr. Harper, our witness's deposition, she said, yes, I did rely on George Torres' medical records. So they were well aware.
That doesn't mean they come into evidence.
I know that. I didn't say that, but they were well aware that that's one thing that she relied upon. A lot of that collateral evidence doesn't come into, and it's going to be.
I need to jump into the breach here. I understand all of that. I understand that there's been volumes of documents that have been provided between both parties. And I understand, based on my review of the highlighted portions that the state pointed out in their motion, as to what Dr. Harper relied upon. None of that is germane to the state's argument. And you've admitted that there needs to be a narrowing down. So let's just kind of compartmentalize what we've got here.
So it's premature. It's premature. I agree it needs to be narrowed down. And then based on Sarah Boone's testimony.
You are the proponent of the evidence. So you have to establish relevance.
I agree.
And you have to establish that is not so substantially unfairly prejudicial.
Yes.
That the prejudice does not outweigh its probative value, including but not limited to the other identifications in 90.403.
Yes, sir.
So my question is, sir, with regard to the 2018 incident of the fist through the plate glass window, and I can't recall 40 some odd pages, I think the state identified as that. What of those 47 pages is germane to an incident of violence that may be needed to establish the self-defense concept of those 47 pages?
It will be relevant after she testifies about that incident.
All 47 pages?
Maybe not all 47 pages. I've agreed that some of it needs to be narrowed down.
Okay, well, what of it needs to be narrowed down? Since
Well,
we have some level of common ground here.
My case is not going to be presented, I would assume, until next week. So I've got a little bit of time. I'll let the state know.
That's not how this works.
Okay. I can't let you know today, Judge. I'll narrow it down, or we'll talk in the next couple of days.
Well,
by
the state's
Friday.
position is that the narrative should be permitted as to the 2018 incident, the why Mr. Torres was there. but the nursing rounds, the charts, the follow-ups, treatment, anything in the future other than the 4.5 centimeter laceration that required 2 sutures. I understand the narrative as to what transpired. What else is relevant? And I haven't seen these 47 pages, so I'm not sure there. I'm relying on counsel's representation.
I don't know. I'd have to look at them, but in one of the medical records, George Torres was over a 0.31 BAC. Every time.
In 2018?
2018.
I'm talking about the 2018 incident with regard to the plate
I
glass
have to look at
window.
the records, but there is other evidence in those records that's going to be relevant after she testifies. That's when she gets beaten, when he gets really drunk. Or that's when he does something violent or threatens to do something violent when he gets really drunk. In one of those incidences, he was over a 0.3. When he gets over a 0.2 to 0.3, that's when he gets angry. He's fine.
Okay, so you want in records showing how intoxicated he was, what his injuries were, and the narrative. That's what we want, Judge. That's what he should say. In the meantime, thank you very much. Langer 1234. It's a trap. If they mention it in opening, talking about battered spouse syndrome, but then cannot get the evidence and or expert testimony, and they look bad to the jury, you have got that 100% correct. To get the expert in, Sarah will have to testify. That's true. And yeah, they will look really bad. It's really a question of, if you're the defense, whether you're going to argue this in opening statement if you can't then get it in with your evidence. So that's definitely a risk you have to think about before you start arguing things during opening statement. All right, let's continue.
Up until that point, we're going to establish that. I don't want to put on my defense today, but Judge, there is going to be relevance to more than just the narrative of those medical records. I'll narrow it down by Friday. That's the best I can do.
Okay, what about the 2017 incident, 487 pages, and those documents pertaining to the facial reconstruction and anything thereafter? What does that have to do with anything?
Same thing. You know, it's going to be based on her testimony, and then the judge is going to have to make a decision about whether that's admissible based on her testimony about what happened.
But what does the facial reconstruction, surgery, pre-surgery, post-surgery notes have anything to do with whether or not that incident actually took place?
That's going to depend on Sarah Boone, depending on what her testimony is, and you'll have to find based on that whether or not that's relevant and probative to the case.
That's not how motions in limine work.
I don't know what else to tell you, Judge. She's going to have to testify, and then we'll make the arguments as to the admissibility of that.
I'm struggling with understanding how I can understand BAC results. I can understand that based on Dr. Harper's deposition. I can understand the narrative as to why they were there. I don't know what are all in these records. What does nursing rounds or pre-op, post-op of facial reconstruction surgery have anything to do with an incident that purportedly took place on December 24th, 2017? How is it relevant?
Some of those may not be. Some of the records may be relevant, depending on Sarah Boone's testimony about how what happened to him was tied to what he did to her.
What does it have to do with the actual rounds? And again, the argument here should be by James Owens that the extent of the injuries also shows how serious the instance was. And that goes to show how violent he gets. He got so violent, or it was such an argument that he really got his face bashed up. And look how much surgery they had to do in order to fix him. And that's all because of his anger issues or whatever. So that should be more the argument than let's just wait to see what she has to testify about. That doesn't really answer the judge's question.
Okay. Anything else?
That's it.
Response.
The two parties' discovery responsibilities in a criminal matter are not equal. The state of Florida has a duty to disclose anything that anybody knows or may reasonably be calculated to lead to relevant information to the defense. The defendant's obligation is to let us know what they're going to use in trial. So for them to come in today on the third day of jury selection and to tell us that it's premature to ask for what is going to be their actual evidence in a trial is wrong. They got these records, and I understand that they're the 9th set of attorneys for Ms. Boone, but the defendant got these records in 2022 or 2021. And they just get disclosed to me overnight a couple of nights ago. In their discovery responses, in the First Amendment, Second Amendment, third, so on and so forth, for weeks they were telling us that they didn't have them and they were waiting for them, but they were sitting in Ms. Boone's box, apparently, that Billy Lane had acquired years ago. So it's not premature to ask, and it's not unfair to ask for what is going to be introduced in this case, or attempted to be introduced, particularly given the court's rulings. We had rulings from this court, I think you entered it August 5th or August 6th, setting forth a schedule for what are you both? And the state too, we both disclosed, what are we actually introducing? The state has actually narrowed down the digital phone evidence from the defendant greatly to about 160 pages of the PDF from the thousands that it was, and handful and a few dozen pictures and videos. We have done everything we can to narrow it down. We're not asking for much here. We're not asking for much. And just to bring the point about the BAC, Jorge Torres had a 342 medical blood, so there's probably some conversion, 10, 15% for legal blood, at the time that he was admitted for his facial injuries. That would be a different picture than on the date of the plate glass window. On that date, again, I expect that the testimony from the defendant will be that he was the aggressor, the violent one, and his blood alcohol level would be relevant for the plate glass window one. But I'm struggling to understand what his BAC's relevance is if we're all at a family gathering at the Torres's and she says something that triggers one of his brothers to violently beat him nearly to death, what his BAC's relevance is on that particular occasion, unless her testimony is the decedent was being violent with her that day. And that's just not my understanding of how the deposition's read. So Judge, we're not asking for much. I don't think Friday's sufficient. We're attaching jeopardy to this case as soon as we swear this panel in, hopefully tomorrow morning. Thank you.
Thank you. All right. The court has reviewed the motion and has reviewed both the arguments. I'm struggling with the relevance on some of these things. So I'm going to grant the state's motion in part to the factual narratives as to why Mr. Torres was seeking treatment. That will be admissible. I'm going to overrule the state's objection with that, and I think they've conceded that that is relevant. Information regarding blood alcohol content in both the December 24, 2017 incident and the 2018 incident, I find potential relevance. So I'm going to overrule the state's objection with regard to those. However, the balance, I'm going to sustain the state's objection and grant their motion in limine unless there's evidence provided in the defense's case in chief that make these other documents relevant. Because at this point in time, it is unclear to me how the balance of other hospital records, nursing rounds, pre-op, post-op, the surgery itself from the 2017 incident are relevant to a fact of consequence, be it any of the material allegations the state needs to establish or any material allegations the defense needs to establish for the purposes of self-defense. I'm not foreclosing you, but there needs to be something for you to link these documents together for me. All right. Any clarification or questions with regard to the state's rule or the court's ruling? Defense. All right. Thank you. That now takes us to the objections to the evidence.
All right. Well, like the judge was leaning the whole time, the narrative is going to be allowed. The BAC is going to be allowed. The narrative, the narrative, the BAC, some of the injuries are going to be allowed, but not more unless there's some reason that Sarah Boone can testify to why they should be admissible or relevant. So we can move on.
We have the defendant's objections to state's digital exhibits filed October 15th. The state's state's response to defendant's fifth amended reciprocal discovery exhibit list filed also on October 15th. I have reviewed these. I'm a little bit of a loss in the state's response because I don't know what items 1, 2, et cetera are. It just identifies them. I'm not sure what it is that they are.
It's tracking their fifth amended exhibit list. As I pointed out before, it got really confusing because as they added things, it would not go to the end of the list. It would get put into the middle of the list. So I started over, scrapped my first response to the first amended one, scrapped my second response to the second amended one, both of which were filed on September 27th in a timely manner. And this is why my paragraphs start with 0 in my response, because they have a paragraph in 1A and then they list the items. And I wanted to make it very easy and clear for the court to just be able to flip to what paragraph I'm talking about for each item tracking their fifth amended exhibit list.
But here's the problem that I'm having. On September 27th, I see the notice of provision of defendant's third amended exhibit list. When was the fifth amended exhibit list provided?
That might be a problem with them not filing things with the clerk of the court.
Okay.
I'm getting copies of some pleadings, but they're not date stamped with the clerk of the court's e-filing system on the top left. So I'm not certain that they've filed anything with the clerk of the court.
Here's the other problem that I have. All I see on my end is the notice of providing. It doesn't identify anything. It's a one-page document. So it's hard for me to say what, I know you may have seen it, but the court hasn't seen it based on what's been filed.
I believe I would direct any questions about why that's not filed with the clerk of the court to the defense.
Okay. All right. I need clarification, Mr. Owens, as to when the 5th amended reciprocal discovery exhibit list was filed and what is in it. Because the notice that I see in the court file from September 27th is just a notice. It doesn't identify anything for me to line up item 1 and item 1 as to what they purport to be.
You're asking for when it was filed? We're checking on that. When it was filed. What was the next question?
All I have is a notice. So on September 27th, there was a notice of provision of defendant's 3rd amended exhibit list. And it's just that. What we intend on utilizing has been provided. I don't have anything else as to what those items are.
Okay. Did you want us to provide you with a copy of those to your JA?
Or you can send it to Madam Clerk and she can print it out to me, because I'm having difficulty lining up what these things are, because all I have in the court file is this was sent on this day, but I don't know what any of these things are.
We can move on to something else.
Unless we've got some housekeeping matters to address for this afternoon. But unless I'm missing something, the only other thing that we've got teed up to address this morning is the objections. Okay. Give me 1 second. All right. I got an email this morning from Juror Services. Juror number 551. I don't recall from what panel. No, I'm sorry. Juror number 471, panel 3, seat 48. Tested positive for COVID, and Jury Services has instructed him not to return. Juror number 551.
What was the first one?
Sure. Juror number 471, panel 3. That would have been yesterday morning, seat 48. Advised Jury Services this morning that he was not feeling well. After leaving the courthouse, he tested positive for COVID. I have instructed Jury Services to excuse him because we don't need that floating around.
It's not pleasant.
The other juror, 551, I don't have any other information as to what panel or seat. She took a COVID test and was negative. She is planning on reporting today. So due to the shrinking from 54 to 53, jury selection will take place here in 12 Alpha this afternoon as opposed to the 23rd floor. The deputies have already brought in additional chairs so that we can fit 53 people in here. That's the only other housekeeping matters that I have to address. So are there any housekeeping matters to address from the state before we address the objections issues?
Is it wise to not utilize that expanded space when two of these panels, or at least one of these panels, has already been exposed to COVID up in the 23rd floor? Would it not be wise to use the bigger space in 23 since one of our panels has already potentially been exposed to COVID, as opposed to packing everybody in sardines?
Response.
I don't know the layout of 23, so
Can you all approach this for a second?
All right. Well, just figuring out where to put all these jurors. 53, 54. They're in a different courtroom before. One of them has COVID. And then there's a bunch of objections that they have to go through. And there's some issues with the filings that the defense apparently did not file. Either they didn't file it properly, they don't have bait stamped by the e-filing clerk. When you e-file something, it gets a stamp. Some of that wasn't stamped, so they're just having some confusion with respect to that. LOC Kick, if I'm saying that correctly. Will you please explain motion rulings at the end? I think I missed stuff and was a bit confused. I did go through all the motions every time he ruled something. I did talk about that. I have to remember off the top of my head all the different rulings that he made today. In terms of the battered spouse, he is allowing mentions of battered spouse in opening statement, but you have to, before evidence of any sort of battered spouse or reputation evidence or violence propensities, things like that, before any of that comes in, he's going to require a foundation to be laid. Some of the comments that were made, some of the statements that were made by the detective, he has stricken. So they're not coming in statements saying about the conclusions of she's responsible, she did it, this is all because of her. He has stricken those statements from coming in. I don't remember anything else. If there's something that I missed, someone can put into the comments.
All right, court's going to take a 15-minute recess to address jury selection location this afternoon. and to give the defense the opportunity to provide the fifth amended exhibit list. With regard to juror 551, what say the state?
No objections. Well, if he doesn't have COVID, then I don't have a motion for cause.
Okay. Any response from the defense? Correct.
Struck.
Correct.
Thank you. Thank you for struck.
I read you what was provided to me. Okay. Court's going to be in a 15-minute recess. Thank you.
All right. Well, there we have it. They're coming back with some boring stuff about some of the objections on the digital evidence or some sort of evidence that there are going to be some objections to. So we're just going to call it quits now. If anybody has any other questions, we can put it in the comment section now. I'll quickly try to go back and see if I missed anything. I know there were some. Okay. All right. Well, thank you everybody for joining. This was very interesting, and some of the rulings were surprising, even to me. So, always never a dull moment here. Trial is going to pick up. They're going to finish off with the objections. They're going to finish off with jury selection, and then we'll see when they actually get to opening statements, which I think right now they're saying is going to happen on Thursday, tomorrow afternoon. I believe they're trying to go for, and we'll see if that actually ends up happening. So if it doesn't, maybe Friday. Either way, next week I'm going to be out, but I'm going to do my best really to cram it all in after the Jewish holiday and bring you my updates and analysis like you've come to expect. So that's going to be it for now. Thank you all for joining the live. Thank you all for the super thanks. Thank you all from all over the country who have tuned in for this. I didn't get to all of you to mention where you're all from, but definitely had a representation from all over the four corners of the earth. So thank you all for joining us. What about the snacks request? Okay. All right. Thank you all. Please, if you haven't yet, subscribe, like, and we will see you next time. Happy holidays. Appreciate you all. See you next time.